We are back, and we are joined now by Ryan Doerfler, professor at Harvard Law School, whose piece in Dissent Magazine, co-authored by Samuel Moyn, who's been on this program before, is entitled "We Are Already Defying the Supreme Court." Ryan, thanks so much for coming on the program.
Thanks for having me.
So you write about how both liberals and conservatives kind of uphold this popular narrative that compliance with the Supreme Court is basically intractable and you've got to do it. But historically, that's not always been the case. And you write about a lot of these examples. If you could explain that dynamic to our audience briefly?
Yeah, I mean, I think as we talk about in the piece, I think there's two types of defiance. There's sort of what we might think of as like extraordinary defiance. So transformative presidents like Abraham Lincoln or FDR either did or credibly threatened to defy the Supreme Court at critical historical moments. Also, less salutary figures like Andrew Jackson. So those sort of overt confrontations of the court, by a sitting president, those are sort of extraordinary acts of defiance, and really not something we've seen in almost a century at this point. At the same time, though, if it would be a mistake to infer from the lack of that sort of overt confrontation that there is a general norm of just sort of strict compliance with Supreme Court orders. So in the piece, we talk about a sort of really wide range of types of either defiance or non-compliance that we see in sort of less visible ways throughout the government, whether it comes to things like sort of negotiating, for example, when a court orders an administrative agency to take some measure. Very often administrative agencies will say, that's not really feasible, and we're basically not going to do that, and that will launch a sort of negotiation between the agency and the court over what the terms of the order are really going to be. Other times you'll see sort of workarounds, right? So a familiar example, if you think about affirmative action, right? The Supreme Court in Bakke says, no more racial quotas, can't do that anymore. And so what we see in relatively quick order is all sorts of universities adopting sort of effective workarounds, right? Using other sort of diversification criteria to basically get to the same place as what the Supreme Court was trying to prevent, just using formally different measures. And I think you're going to quickly start to see a similar dynamic play out here following the Supreme Court's decision in the SFFA case. Even more sort of dramatic, there are also examples of just sort of actually outright defiance where a court will, let's say, order the Department of Homeland Security not to remove some person from the country, and DHS will simply ignore that order or remove the person, knowing that such an order is on its way. In contrast, though, to those earlier extraordinary examples, those are sort of like below the radar actions. So these are not cases that the president would necessarily tout, right? Sort of try to make political hay out of that act of defiance. Nonetheless, we do see that sort of even direct defiance in some cases.
I don't know if I could see a Democratic president in my lifetime making that, saying that publicly, that defiance would be their own policy, just kind of given the constitution of the party. But Republicans might, and Democrats may just engage in it kind of quietly. You can make an argument that Biden's piecemeal student loan forgiveness is in defiance of the Supreme Court's decision from last year.
Yeah, no, I think that's right. And part of this goes, so I think, so two thoughts. So on the one hand, I think especially for someone like President Biden, who is a sort of staunch institutionalist, like really believes in the importance of the sort of reverence for the Supreme Court as an institution, someone like President Biden is just really reluctant to openly engage in defiance of the Supreme Court. At the same time, I think the student loan example is an excellent one in that I think outside pressure on Biden to push back against the Supreme Court's decision dealing with the first student loan program shows that even somebody who is reluctant to engage in that sort of direct confrontation can be pressured to do something that at least pushes up against that sort of direct defiance, right? So in the immediate aftermath of the Supreme Court student loan decision, within hours, President Biden, said that the decision was wrong, said that it made him angry, and announced that the Department of Education was going to immediately pursue student loan cancellation using a different path. And I think there's at least a very plausible understanding of defiance or non-compliance, where we would say that what President Biden is doing there is defying, is refusing to comply with the Supreme Court's order.
Can we go back to the beginning? And your piece writes about Marbury versus Madison, which basically established the power for courts to have judicial review, and that's now been interpreted by a lot of institutionalists, really, and or is specifically some right wingers on the court these days as judicial supremacy. But even Thomas Jefferson kind of defied that during that in the wake of the Marbury versus Madison decision in 1803. What happened there, and how did it kind of set the stage for some of the the issues that we are presented with the Supreme Court's seemingly like unending power?
Yeah, I mean, Marbury is an interesting case. So on the one hand, right, so Marbury was sort of the first case where it seemed that the Supreme Court was poised to order President Jefferson to seat opposition party members as Justice of the Peace in Washington, D.C. And Jefferson, at least according to the historical record, seemingly credibly threatened to defy an order to that effect. And so what the Supreme Court did in an effort to preserve its apparent power, its apparent legitimacy, was declare that actually it lacked jurisdiction over that case because Congress had unlawfully assigned it. It had attempted to assign it jurisdiction in contravention of the Constitution. And so this is often sort of presented as this sort of strategic coup from Chief Justice John Marshall at the time, where he established the power of the court to declare legislation unconstitutional by taking a measure that President Jefferson actually liked, right? Avoiding this direct confrontation. Now, I will say, and this is sort of described in great detail in a forthcoming book by my colleagues Nico Bowie and Daphne Renan, that sort of narrative around Marbury versus Madison is really establishing the power of judicial review is kind of a sort of historical myth, right? At the time, sort of Marbury was decided, but then sort of the court really didn't assert its authority to engage in the sort of interventionist sort of approach that we are familiar with today, really until around the Civil War period. And that sort of narrative about Marbury being the origin is sort of a court-manufactured myth.
It's convenient for them because then they can just engage in what they're doing right now, which is any kind of anything passed through the legislature that we have an issue with, we can cut into it or make it more difficult to implement. This concept of basically defying or disobeying the Supreme Court seems more relevant now than ever. You mentioned the FDR example about how he defied the Supreme Court twice, and both of those seemed quite righteous. Do you mind explaining those examples to the audience?
Yeah, or to be clear, credibly threatened to defy the Supreme Court, at which point the court backed down in both cases.
Yes.
No. But I think that shows that what that shows is that the Supreme Court itself is very sort of careful to try to preserve this narrative of compliance, right? So, and the two examples that we mentioned in the piece. So one, when Roosevelt and the Democrats attempted to shift the U.S. off of the gold standard, there were sort of rumblings that the Supreme Court during the sort of Lochner period were pushing back against sort of progressive economic regulation, some threat that the Supreme Court would declare that act unconstitutional. There, President Roosevelt again threatened to defy, and the court ultimately backed down. And the other example was the decision to try alleged Nazi saboteurs in the U.S. via military tribunal rather than in an Article III court. There again, the sort of clear implication from President Roosevelt was that to the extent that the court were to say, no, you have to try these alleged saboteurs in front of an Article III court, that Roosevelt was simply going to defy that order. And so again, the court backed down.
You write that the role of the judiciary exists within, quote, politically constructed bounds, or you quoted Richard Fallon saying that. Can you define what those bounds are? And if you could answer whether that's always been the case or if this is a newer phenomenon that's maybe ramping up.
Yeah, no, I think in some ways it's unavoidable that the scope of judicial authority is politically constructed, in the sense that the scope of judicial authority in practice is, when the court says do such and such, do people listen or not? And that's always an open question, right? That's just a sort of social norm that we, comply with court orders or we don't. But what we see sort of throughout the court's history, again, is it sort of testing out and sort of carefully attempting to expand the range of intervention. So again, going back to the Marbury example, right, for almost the first century of the court's existence, right, there are sort of basically no examples of the court sort of openly declaring acts of federal legislation unconstitutional, right? And why is that? Well, in part because, again, there's this sort of apprehension that people are just going to ignore the court or get really angry at it, and Congress or the president will retaliate. And so in an effort to sort of avoid that sort of retaliation, we see the court be very cautious. Again, sort of starting in around the Civil War period, we see the court attempt sort of pretty aggressively to expand its power. But again, sort of throughout that, there is just this sort of ongoing negotiation, both between the court and the other political branches, but also in turn, right, there's a sort of ongoing or at least should be an ongoing conversation or contest between the court and the public. And so I think part of what we try to emphasize in the piece is that in many ways, that sort of ongoing contest in those earlier moments where we saw presidents politicize their confrontation with the court, the public sort of was made aware that sort of how much authority the court ought to have is a live question that we have to answer as a democracy. Whereas now, because that sort of the contest over, okay, how far can the court go? Because for so many decades, that sort of push and pull between the court and the president, or between the court and Congress, has been sort of obscured, sort of shoved into sort of more obscure spaces within the administrative state, often sort of explained in sort of opaque legalistic terms. That can give the impression that, again, that there is no ongoing contest, which then changes the character of the contest. It shifts it from a contest between, at least potentially, the public and the court to, in effect, a contest between elites that the public is simply unaware of.
And I think that is a great way to segue into just asking if you could make the distinction between the rule of law, or basically defying the law, versus defying the courts. What is that difference, and what should our audience know about that?
Yeah, totally. So I think there is, and again, this is like a real success on the part of the court, but I think with complicity of the president and Congress over time, to think that to defy a court is sort of per se to defy the law, right? If we don't follow judicial orders as a strict rule, that we simply live in a lawless society, right? And I think it's sort of very easy, I think, to explain why that sort of equivalence between rule of law and rule of judges are not one and the same. Because I think if you go back to, for example, the student loan case, I think it's fair to say at the very least that, or in the court's opinion, right, the court says, we read the statute so as to clearly preclude the debt cancellation program that President Biden has implemented. And as Justice Kagan says in her dissent, and again, Justice Kagan is really a judicial moderate, right? She's not some sort of left-wing firebrand by any stretch, but Justice Kagan says, look, to reach this conclusion, the court has had to invoke this thing that it calls the major questions doctrine, that says that we should look skeptically upon claims of sweeping authority that agencies identify in existing statutes. And she says that doctrine is simply made up. She says it's a made-up doctrine that the court invokes to deprive the Department of Education the power that it otherwise plausibly has under the statute. And so if you agree with Justice Kagan that the Supreme Court is using a quote-unquote made-up doctrine to prevent the Department of Education from taking this step, were the Department of Education simply to ignore the court order and cancel student debt, I think it's at least, it's not straightforward. Sort of who's behaving lawlessly, right? Is it the Department of Education by ignoring the court, or is it the court by attempting to prevent the Department of Education from taking a step that the statute at least plausibly allows, again, by appealing to this made up doctrine?
And this major questions doctrine is going to be employed even more as this kind of right-wing Supreme Court begins to look into whether or not it has the authority to regulate the expertise of agencies. And then the Chevron doctrine is kind of hanging by a thread. It feels like this kind of concept of disobeying the Supreme Court or defying it is going to have relevance if this attempts to hamstring agencies from doing kind of any regulations throughout without going through the legislature as is being floated.
Yeah, no, I think that's exactly right. Because on the one hand, I do think that the popular reaction to Dobbs in some ways did sort of chasten the court. and that the court has been in various contexts, like the voting rights context, for example, a little more cautious in advancing its conservative legal project. But the exception, though, I think, is really in the administrative context, where there again, I think the student loan decision is the clearest example, but there are several others where, notwithstanding the backlash in the reproductive rights space, the court seems to be going full bore on its sort of anti-administrative project. So you mentioned the Chevron decision, which seems very likely that the court will either reject or significantly sort of water down the doctrine that agencies should enjoy deference when interpreting the statutes that Congress has tasked them with administering. But also other cases. There's the sort of Jarchesi case, where it seems very likely that the court will hold that agencies can't issue certain types of remedies, in particular significant fines, saying that no, if fines are going to be used as a remedy, have to go to an Article III court. So there are all kinds of places where I think we will see the court continue quite aggressively in its effort to limit administrative authority in all kinds of areas. I think also, if you think ahead to the FTC's non-compete rule that it just promulgated the other day, I think that's very likely to find its way to the Supreme Court in short order. And so all of those cases, I mean, these are really incredibly important policy decisions that the court is attempting to take away from agencies and give to itself. And so in those cases, I think those, especially those very high stakes cases, at least contemplating various forms of pushback, I think is essential.
Ryan, before we let you go, I couldn't have a Harvard law professor on without just asking you a bit about your thoughts about the encampments and the protests that are going on at Harvard. I saw an encampment was put up today or yesterday by students basically protesting genocide in Gaza. As a professor, what's your take on that?
Yeah, I mean, my take most immediately is that I'm just incredibly proud of the students for the bravery that they are showing, not just now, but throughout the conflict. There's been a very committed group of students who have continued to speak out despite a sort of very oppressive environment, and I just continue to admire them. I mean, that's obviously not true just at Harvard. I think like the actions of students around the country have just been so heartening, and I really just urge faculty to do everything that they can to stand with them. Here I will say, happily at Harvard, at least thus far, we haven't had the sort of police intervention that we've sort of seen at other institutions. Right. But I think, faculty, I think, really owe it everything they can do to support the students as they take this very brave stand.
I'm glad to hear that with Harvard, and let's hope that stays that way. Ryan Doerfler, the piece in Dissent is called "We Are Already Defying the Supreme Court." Maybe send that around to some of your liberal institutionalist family and get them thinking about things a little more critically and challenging this extremist Supreme Court. Thanks so much for your time today, Ryan. I really appreciate it.
Thank you.